Today I'd like to introduce Max Schatzow. Max is an associate in the law firm Stark & Stark, and he works in their investment management and securities group. Max concentrates his practice on counseling financial service entities, including investment advisors, broker-dealers, and private investment companies on registration, compliance, liability, and litigation issues. Max received his JD from the University of Miami School of Law. Welcome, Max. It's nice to have you here. Can you please tell us your current job, a bit about it, and some of your background?
Absolutely. So I'm an attorney with the law firm Stark & Stark, and I've been with the firm for roughly about 6 years now. And so I represent primarily investment advisors, but some broker-dealers, some hedge fund managers, some private equity managers. I focus primarily on regulatory and compliance issues. Our main goal is to help clients stay out of trouble. There's a lot that goes into that in terms of, knowing your client, knowing the regulations, knowing how those regulations are interpreted and applied. The clients we represent are on the smaller end in the industry. We're not representing Merrill Lynch, Morgan Stanley. We are representing, usually a breakaway from one of those big firms, I would say, who wants to go out and start their own business.
That's really interesting. And could you sort of say what portion of your work is kind of helping people get set up, starting their businesses, compliance, and dealing with regulatory issues? And then how much of it is on the other side, once they're up and running, kind of dealing with problems as they come up, or, helping them interpret new regulations?
I would say 10% of my time is focused on, helping clients become registered with the SEC or a state regulator. The rest of my time is really on developing policies and procedures, helping clients implement those policies and procedures.
So you work with these clients to implement and adhere to regulations. Can you talk about some of the challenges that come with that job?
Yeah, absolutely. There's a lot of challenges. The biggest one I find is really getting a client to appreciate and understand the risk of a specific rule or regulation. Most of our clients, they're not lawyers, they're not, compliance professionals. They are truly, business people, people who want to go out and manage money for a living. Getting a client to understand what the rule is, what the law is, how to appreciate the risk of that rule, and then implement it. That's always the biggest challenge. The other issue that we have is really getting clients to sort of understand and dedicate the appropriate level of resources to regulatory issues and compliance. It's like working with my children sometimes. You're always fighting that battle of, is it worth it? Do I need to do it? Why do I need to do it? Those are really, the big challenges. There's so many, to be honest, but they're all enjoyable challenges, and we work with them regularly.
I imagine in a smaller firm, it's just staffing, right? So they don't have a huge number of people to devote to compliance. It's challenging. I agree that it's rewarding. And for you in particular, there are some serious consequences to not complying. So I think, you're both the carrot and the stick in many cases, just like with our children, right? So, but there are long-term payoffs for that kind of behavior.
Exactly.
A lot of my work tries to focus on solutions to conflicts of interest, and you're also trying to deal with that in your practice, but we don't always have the exact same perspective or solution. So can you talk about some of the possible unintended consequences of regulation, specifically if regulation seems onerous?
Absolutely. Yeah. There's a lot of unintended consequences, or really just, consequences. Maybe some of them are even intended. The first one I would address is sort of regulation is complex. Anytime a rule or a law is passed, there's this whole standard or body of law and rules already, right? And so the first thing you have to do is, figure out how does it fit in with this whole body of, law. So sometimes you'll get a new rule that is quite honestly conflicting with a current body of law. There's other times you'll get a new rule that doesn't fit in very neatly. And so, that's always one of the big challenges when a new rule comes out is how does it fit into this current, field? And then how do we apply that into a client's business? The other part of that is that there's multiple regulators involved in my industry and almost every industry. We've got the SEC, we have FINRA, we have state securities commissioners, we have the Department of Labor, we have the IRS, the FBI. I mean, it's an acronym soup, and there's just so many people who are looking at our clients and wondering, are they doing the right thing, trying to make them do the right thing, looking out for investors, looking out for the industry as a whole.
Yeah, I think a lot about just trying to implement regulations, and you and I and all of us who assess these regulations, we sit back and say, like, does this really have to be 700 pages long, right? But then you start digging in and you realize, like you talked about sort of first point, it's really complex, and sometimes the answer might be yes.
Right. I mean, the answer, we always want it to be so simple and just to be a yes or a no, but it rarely, if ever, is just so easy.
So one of the things that sort of comes up fairly often if I'm reading about different regulations is some of the pushback from industry says, hey, SEC, you've had this rule on the books for a while and it's been super vague and you haven't regulated it very carefully. And now suddenly you're coming in with a hammer. And so the terminology I read is regulation by enforcement. And can you talk a little bit about what that looks like and why that can be problematic for both the industry and specifically for your clients?
The concept in and of itself isn't a problem, right? I mean, enforcement is a natural part of regulation, right? I mean, rules are made to be followed, and you're supposed to follow them. And if you don't, there's going to be an enforcement of that rule. Right. The problem in our industry that we have been seeing of lately is this concept of regulation by enforcement, which really means the rule doesn't say specifically do this, do that. But the regulators are interpreting it to say, you can do this, you can't do that. And so it's really difficult in the industry to predict how a regulator is going to interpret a rule that is unclear. In my role, we're trying to, predict really, how a regulator is going to fill these gaps. Right. And in honesty, the job would be so much easier if they just have a rule that says what they want it to say.
Yes.
And so this is the battle over regulation by enforcement. And I think we all agree on the outcome. It's just how we get there, is how we disagree on it.
Yeah, no, that's a great point. And the idea is that if you have kind of the same goal, then you can work towards it. It's really just, how can we do what's best for consumers without so much regulation that's so complicated and so difficult to enforce. And then one of the things that I think a lot about, because it's fun to think about but hard to pin down, is this idea of the spirit of the law versus the letter of the law. So the letter of the law says you can do X, Y, and Z, but often it's vague and maybe intentionally so. But can you talk a little bit about that tension between kind of spirit and letter? Because I think it's fun to think about.
In reality, in practice, we're battling that all the time, right? I mean, we try and look at adopting or proposed rule releases, and we're trying to figure out oftentimes what the spirit of the law is, right? I mean, it's very easy to open up a statute or a book or a rule and say, oh, that's what the rule says, right? It says, right, you must disclose conflicts of interest. So to tie that in here, the spirit of the law is to make sure your clients are aware of, who they're dealing with, what they're dealing with, what kind of conflicts are present. Does this person have my best interests in mind? The letter of the law, as you know, disclose material conflicts, right? And so, we're always battling what that means. We go back to this concept, the spirit of the law, and we're trying to figure out, either in 1940 when the body of our law was created, or more presently when these rules were amended, or even new rules come about. What was the spirit of the law? And it's really a fun exercise in guessing sort of what someone meant when they were proposing rules way back then. And I really do. It's one of my favorite parts of the job, to be honest, is exploring that distinction.
It's thinking about what the intent is, thinking about how to implement that without violating the spirit, but not getting so codified where you could make a hard and fast rule that could end up actually hurting clients, even though it has every intent of being good for clients. And really appreciate all your thoughts and your comments here. Thank you so much for chatting with me, Max. And I really appreciate it. Thank you.
My pleasure. Take care.
You too.